quality and the quantity of the water is influenced, because if too much water is extracted, the rock, which is filtrating the surface water, will get dry and will change its structure.
And I thank God for the public health prophets and technicians that decided in this country that public water was necessary to maintain the health of the people in this country. Throughout the country, we have that now because of that effort. I ask that the planning board decide to use what influence you have to help the selectmen decide to set aside this ordinance and to put a vote to the people, up or down, secret ballot. Do we want the large-scale extraction of water here in Wells or not?
By a lot of people. Poland Spring was one of them. At the meeting in question, they did in fact hand us some literature. I don't honestly remember exactly what it was. They did not write this ordinance. We started with the Denmark ordinance, and I'm not sure of its ancestry, and I don't particularly care. I think it suits our needs. We tailored it for our town. I think it will protect our water. Having said all of that, I hope that you put this before the people for a vote. If people don't want large-scale water extraction in town, they simply have to vote no.
As a public servant of this town and the 6 surrounding communities for the last 25 years, I feel I have to set the record straight on some factual information that has been being said tonight. That is not at all factual. First, I'd like to comment on the ordinance. You will find from your own legal counsel, from the Attorney General's office, from the DEP, from any agency out there or any lawyer out there that understands law, that your regulatory ordinance is probably your best bet, if not your only bet, of protecting the town. If you have a ban of it, that won't stand up in court, and the rights base won't stand up in court. So we have gone to groundwater for 40% of our water needs now. Groundwater is less than half the cost per gallon to treat, and is much better quality water for our customers than Branch Brook water. Less carcinogens are formed by the chlorination process, minuscule amounts, and it's more stable all the way through our system, and more consistent temperature and quality. That's why we're leaving Branch Brook as our primary source, and we're trying to actively develop other groundwater sources. Since 2002, 2003, the last drought, we've developed 3 million gallons a day of groundwater supply. As of today, most of our water today is coming from the ground, not out of Branch Brook, but out of another watershed, as of right now, this minute. Okay, so again, for the last 2 years, we've been in full compliance, exceeding the required flows every month of the year. And in the last 2 years, we have developed that additional 3 million gallons a day of groundwater. And on a final note, with respect to no money coming into the town, I'm not, as you know, my board has a position on where they stand right now. I'm just throwing out a hypothetical. If something had happened or were to happen, whereby the water district were to enter into a contract with someone, and if that, let's say, pick a number, if we were to get the non-profit water utility that serves part of 7 towns, Kennebunk, Port Wells, Arundel, Ogunquit, part of Biddeford, part of York, if we, the non-profit utility, with no stockholders, were to get $1 million, they'd be $270,000 of that. 27% of that would benefit the town of Wells, because currently Wells is 27% of our revenue base. So that $270,000 would go toward offsetting our costs of operating our utility. Okay, and that's cost the town pays for public fire protection, and all the ratepayers in Wells pays. So directly, $270,000 a year will be coming into the wallets of our residents in Wells and the town and the taxpayers by offset costs that are offset by this other revenue stream. Additional revenue into a nonprofit entity. It's almost like sending $270,000 into the tax dollars of the town of Wells. The only difference here is it's reducing your fire suppression, which is tax dollars, and it's the individual customers that are getting that savings. $270,000 out of $1 million. Okay, so there is some pay there if this were to happen.
My community, we draw from the same water as the people in Wells, the Branch Brook Aquifer. So of course it's a big concern to me and to my neighbors. I know you think you've written a perfectly fine ordinance a regulatory ordinance. But you should speak to Tara Swear of Michigan. The people in Michigan thought they had a great ordinance too. And they have spent years and years and years in court and in debt. And I do not want to see our community go through what they have gone through.
Shapley, and I just want to address the people of Wells in particular. A regulatory ordinance, as you probably already know, but I'll reiterate it, is an invitation for large-scale corporations to come in and apply and meet the requirements of the ordinance, thereby getting a permit to extract. And I also want to tell Mr. Labby that the rights-based ordinance that has been passed in about 70 communities within the United States has never been tested, so he really probably shouldn't be saying that it wouldn't fly by any court system.
Good evening. My name is Andrew Fisk. I'm the Bureau Director for Land and Water Quality at the DEP. I'm not taking any position on the ordinance or the matter at hand. I would offer any answers to questions that may have arisen as a result of DEP jurisdiction. I think I would just note there has been some testimony that I think is slightly related to your deliberations on the ordinance, and that has to do with the water certificate that was mentioned and the in-stream flow and water level rules. I would just note that the district has not finished obtaining a water quality certificate. That is a process that is currently underway with the state. I think what's important to note about that process is the legislature said there needs to be sufficient flow in streams and a sufficient amount of water in our surface water bodies so that all of the state water quality standards are protected. However, water districts, because they have existing infrastructure, should be treated slightly differently. And they, yes, can apply for this certificate, which walks and talks somewhat like a waiver. I think what's important to know is the legislature also said that if a district is going to significantly depart from existing or grandfathered conditions, so let's say a district was going to put in a new source, whether it was of their own volition or through a contract arrangement or anything, their supply was going to significantly change after the time these rules went into effect. The state, between the Drinking Water Program, the DEP, and the Public Utilities Commission, would essentially push that utility as far as possible to meeting water quality standards. So I think in the example where Nestle would be coming in and coming up with an arrangement for new supply with KKW, the state would look at that and say, KKW, you're expanding your source, you are increasing revenue, you have funds available, so therefore, if Branch Brook below the dam is not meeting standards, you need to do more, effectively pass water beyond the dam, so as to improve or meet water quality standards. So they are not waived from meeting standards. They essentially need to do as much as is feasible given what they have for resources under a changed circumstance. I'm a member of the Water Resources Planning Commission, so I represent the DEP on the commission. That Water Resources Planning Committee, in addition to the Citizen Trade Policy Commission and the Attorney General's Office, will be over a series of meetings this fall exploring essentially two questions. Should property law around groundwater change? Because as folks have heard, groundwater is privately owned. It's a modified property right, but it is privately owned. Should that change? What does it mean if that is to be changed? And then the question of whether international treaties could override a local permit or a state permit. And much of the analysis on that has been talked about by the AG, and some of the information you have in front of you speaks to whether that is a significant policy question or not. But this group will evaluate that and present recommendations to the legislature, I think by January or February. January 1. I'll answer your question from the perspective of the state. The state is comparable to the town in that we have regulatory authority over groundwater extraction. So the state has looked at this question, and that we are comfortable that when the state exerts its police power, takes a regulatory action, we do not feel that existing international trade relationships are going to undo our permit. Now, that doesn't say there couldn't be a challenge, because anybody can sue or make claims, and there have been many claims. But when we've spoken to the Attorney General, they have said as long as an action by the state, and comparably, I would assume, a municipality, as long as it is reasonable, it's not capricious, you have findings, and it is based on a factual record, someone could sue or make a claim under an international treaty, but it is very unlikely that they would prevail. So that is the state's perspective.
What kind of protection will we have if they're pumping and we need to pump more?
This is an extremely emotional issue for a lot of folks, and I think we, by and large, dealt with issues and not personalities and other foolishness tonight. So I would thank all of you for your kind attention and your civil actions in this room this evening. Thank you.